1. Scope and covered conduct. Sexual exploitation of a minor under the federal statute 18 U.S.C. Section 2251, sexual exploitation of children. The law prohibits employing or using children for sexual explicit conduct in order to produce visual depictions, videos, photographs, etc. Specifically, Section 2251A covers persuading, enticing, coercing children, or transporting them with intent that they engage in sexually explicit conduct for producing visual depictions. Section 2251B covers a parent or guardian knowingly allowing a minor to engage in sexually explicit activity for the purpose of producing images or videos that will be transmitted across state lines. Section 2251C prohibits employing children in sexually explicit conduct outside the U.S. for the purpose of producing visual depictions that will be distributed in the U.S. Charlotte Lawyers Section 2251D prohibits knowingly advertising or offering to buy/distribute/receive visual depictions of minors in sexually explicit conduct or seeking participation of a minor in such conduct. This shows the federal law has a broad reach: production, distribution, international elements, outside U.S., interstate transmission, and solicitation/advertising. North Carolina state law. Under North Carolina law, the statutes refer to sexual exploitation of a minor, rather than necessarily using the child pornography label. For example, NC General Stat. Serfert 14-190 1-6 defines first-degree sexual exploitation of a minor as knowingly using, employing, inducing, coercing, or facilitating a minor to engage in sexual activity for a live performance or for producing visual material, permitting a minor in custody or control to engage, transporting or financing transport of a minor with intent to engage, recording, photographing, duplicating materials depicting a minor in sexual activity, creating materials for sale or pecuniary gain, or creating a child sex doll of an identifiable minor. NC General Stat. 14-190-17. Second degree. Covers recording, photographing, duplicating material that depicts a minor engaged in sexual activity, distributing, transporting, exhibiting, receiving, selling, purchasing, exchanging, or soliciting material of this kind. NC General Stat. Favor 14-190-17A, third degree, covers simple possession of material containing a visual depiction of a minor engaging in sexual activity or a child sex doll, when the person knows the character or content. So the state law also covers production, transportation, distribution, and possession of visual depictions involving minors, as well as live performances and child sex dolls. Comparison of scope. Both laws cover the exploitation of minors via sexual activity, production of depictions, and distribution/possession. The federal law emphasizes interstate or foreign elements, transport, distribution across state lines, production abroad, and also includes solicitation advertising segments. The North Carolina law breaks down degrees, first, second, third, with ascending severity for production/access or distribution/possession, and incorporates child sex dolls explicitly in state law. The state law does not require interstate or foreign elements for many of its provisions, though transportation across the state is covered. The federal law is broader in geographic reach, across states abroad, and in categorizing various conduct, e.g. advertising. Generally, there needs to be a degree of multi-state activity or the capability of multi-state activity for the federal government to have jurisdiction. Degrees, levels, and punishments. Federal law. Under 18 U.S.C. Section 20251, offenders face very serious penalties, including sentences of 15 years to life imprisonment, depending on criminal history and other factors. The page says, a person convicted under any section of 2251 may be sentenced to 15 years to life in prison. North Carolina state law. The state statute divides into degrees with distinct classifications and penalties. First degree, GS 14-190, 1-6, is a Class C felony, for most violations, and if involving child sex doll or modification for sale, it may be Class D. Second degree, GS 14 to 190, 117, is a Class E felony. Third degree, GS 14, 190, 117A, is a Class H felony. Comparison of punishments. Both federal and state laws treat exploitation of minors as very serious crimes with potentially long terms of imprisonment and life-altering consequences. The federal law can impose life sentences and begins at very high minimums, 15 years in the cited example. The state law has a tiered structure. Lesser degrees, possession, carry lower felony classes. Higher degrees, production, facilitating, carry more severe classes, Class C. The state law also imposes mandatory outcomes beyond imprisonment, e.g., sex offender registration, though those details are less emphasized in my sources here. For example, one summary notes that under North Carolina law, after conviction of first-degree exploitation, one must register as a sexually violent predator. In general, the federal penalties appear to be more severe by default, especially when interstate or international elements are present. Key legal elements and defenses, federal law. Key elements: use, entice, coerce, transport a child with intent to produce visual depictions. Guardian: allowing child to engage in sexually explicit activity for the purpose of images. Distribution of images created abroad. Advertisement, solicitation of minor sexual depiction. The child is defined as under 18. State law, key elements. Knowing the character or content of the material for second or third degrees. For example, third degree requires knowing the character or content of the material containing a minor in sexual activity. Mistake of age is not a defense in North Carolina. For example, mistake of age is not a defense appears in 14 to 190. Yikes, and 14 to 190. A. The state law allows inference that the person depicted is a minor if, by title or text/visual representation, the participant appears to be a minor. Comparative legal elements and defenses. Both laws require, in many cases, knowledge of the conduct and intent, e.g., producing, distributing. The state law explicitly handles mistake of age as not a defense. The federal law page doesn't highlight that explicitly in the quoted section, but typically federal law may also treat some age mistake defenses differently depending on statute, though we don't have that explicitly here. Both laws allow for material involving minors, even if created by technology. State law addresses created, adapted, or modified to appear a minor is engaged. Whereas the federal law has broader jurisdictional hooks, interstate transport, foreign production. The state law is more focused on acts within the state, though it covers transport through or across the state in certain sections. Jurisdiction and why both matter. Federal jurisdiction exists when the conduct crosses state lines, involves interstate or foreign transport distribution of child sexual exploitation materials, or involves federal statutes such as 18 U.S.C. Secretary 2251. Because the federal law has national and international reach, cases may be prosecuted federally when they meet those extra jurisdictional elements. State jurisdiction, here North Carolina, covers violations of state statutes regarding sexual exploitation of minors, production, distribution, possession, regardless of whether interstate or foreign elements exist, as long as the act occurs under state law. This means a given act could potentially give rise to both state and federal charges, if federal jurisdictional criteria are met, or may only trigger state charges if it remains wholly intrastate. From a defense perspective, it's crucial for a charged person to understand both systems. The federal system often has harsher penalties, more resources for prosecution, and different procedural rules. The state system may have more flexible plea bargaining or local practices, but still carries heavy penalties and lifelong consequences, e.g., sex offender registration, Long prison terms. Similarities and differences. Summary similarities. Both federal and state laws treat the exploitation of minors via sexual activity and the creation, distribution, possession of visual depictions of minors engaging in sexual activity as serious crimes. Both statutes include production, distribution, transportation, and possession of materials involving minors in sexual conduct. Both impose very heavy consequences, prison, registration, and do not treat these lightly. Both include knowledge or intent elements, though degree may differ. Both preclude mistake of age. State law explicitly, federal law likely but not detailed in our sourced page. Differences. The federal law includes interstate and foreign components, transporting across state lines, overseas production as distribution, and solicitation/advertising provisions. The state law focuses more on in-state acts and classification by degree. The state law provides a tiered degree system, first, second, third, with distinct felony classes, Class C, E, H, and penalties tied to those classifications. The federal law speaks broadly of 15 years to life depending on history. The state law explicitly addresses child sex dolls, involving identifiable minors, creating for sale, and modified visual material. The federal statute page mentions employing children or transporting them for producing visual depictions, but our source does not mention dolls specifically. The state law clarifies that mistake of age is not a defense, which it states unambiguously. The federal law page doesn't highlight that in the excerpt we reviewed. Enforcement and resources differ. Federal prosecution often involves federal law enforcement, U.S. attorneys, and the possibility of national federal sentencing guidelines. State prosecution uses state-local law enforcement, state attorneys, and state sentencing frameworks. Conclusion. In conclusion, while both the federal statute, 18 U.S.C. Secretary 2251, and the North Carolina state statutes, GS 14-190-116, 14-190-117, 14-190-117A, aim to combat the sexual exploitation of minors, they differ in scope, jurisdictional reach, structure of degrees and penalties, and procedural aspects. If someone is facing charges of this nature, it is crucial to evaluate whether federal jurisdiction applies, which often means higher stakes, and whether the conduct triggers state law charges, and to understand how each system handles elements such as intent, knowledge, age mistake, and distribution/possession of materials.